I note the presence of His Excellency Philemon Young, President of the 79th session of the United Nations General Assembly in the Great Hall of Justice today, in addition to the representatives of the many states and international organizations that have taken part in these proceedings. The questions on which the advisory opinion of the Court has been requested are set forth in Resolution 77/276, adopted by the United Nations General Assembly on 29 March 2023. By a letter dated 12 April 2023, the Secretary General of the United Nations officially communicated to the Court the decision taken by the General Assembly to request the Court to render an advisory opinion. The final paragraph of the resolution reads as follows, I quote, "The General Assembly decides, in accordance with Article 96 of the Charter of the United Nations, to request the International Court of Justice, pursuant to Article 65 of the Statute of the Court, to render an advisory opinion on the following question. Having particular regard to the Charter of the United Nations, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the United Nations Framework Convention on Climate Change, the Paris Agreement, the United Nations Convention on the Law of the Sea, the duty of due diligence, the rights recognized in the Universal Declaration of Human Rights, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment. A. What are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? B. What are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to 1. States, including in particular small island developing states, which due to their geographical circumstances and the level of development are injured or specifically affected by or particularly vulnerable to the adverse effects of climate change. 2. Peoples and individuals of the present and future generations affected by the adverse effects of climate change." End of quote. In accordance with the usual practice, I shall not read out the introductory paragraphs of the opinion. These paragraphs set out the main elements of the procedural history of the proceedings. I shall also omit or summarize some of the other paragraphs of the opinion. I shall therefore begin the reading of the advisory opinion at paragraph 37. The full text of the opinion will of course be available at the close of the sitting. When seized of a request for an advisory opinion, the Court must first consider whether it has jurisdiction to give the opinion requested, and if so, whether there is any reason why the Court should, in the exercise of its discretion, decline to answer the request. The first question put to the Court concerns the obligation of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases, which I shall refer to as GHGs, for states and for present and future generations. The second question concerns the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment, with respect to states and peoples and individuals of the present and future generations affected by the adverse effects of the climate change. The Court considers that these questions are legal questions. The Court concludes that it has jurisdiction to render the requested opinion. It then concludes that there is no compelling reason for it to decline to give the opinion requested by the General Assembly. Turning to the relevant scientific background, the Court notes that the consequences of climate change are severe and far-reaching. They affect both natural ecosystems and human populations. These consequences underscore the urgent and existential threat posed by climate change. In its examination of the scientific aspect, the Court relies primarily on the reports of the Intergovernmental Panel on Climate Change, which I shall refer to as the IPCC. Participants agree that these reports constitute the best available science on the causes, nature, and consequences of climate change. The Court further observes that the adverse effects of climate change on the climate system have been acknowledged by the United Nations, including UNEP, and its special agencies such as the WMO, WHO, and the IMO. The IPCC defined the climate system as the global system consisting of 5 major components: the atmosphere, the hydrosphere, the cryosphere, the lithosphere, and the biosphere, and the interactions between them. For the purposes of this advisory opinion, the Court notes that this definition is substantially equivalent to that of Article 1, Paragraph 3 of the United Nations Framework Convention on Climate Change, which I shall refer to as the Framework Convention. Article 1, Paragraph 3 of the Convention defines the climate system as the totality of the atmosphere, hydrosphere, biosphere, and geosphere, and their interactions. The IPCC has concluded with very high confidence that risks, projected adverse impacts, and related loss and damage from climate change will escalate with every increment of global warming. It added that these risks, projected adverse impacts, and related loss and damage are higher for global warming of 1.5 degrees Celsius than at present, and even higher at 2 degrees Celsius. Indeed, in 2018, the IPCC concluded with high confidence that, I quote, warming of 1.5 degrees Celsius is not considered safe for most nations, communities, ecosystems, and sectors, and poses significant risks to natural and human systems, end of quote. The Court then turns to the scope of the questions posed by the General Assembly. Regarding their material scope, the Court considers that the 2 questions put to it are interrelated and require the Court to identify the obligation of states in respect of activities that adversely affect the climate system, as well as the legal consequences arising from the breach of these obligations. In this regard, the Court is further of the view that the relevant conduct for the purposes of these advisory proceedings is not limited to conduct that in itself directly result in GHG emissions, but rather comprises all actions or omissions of states which result in the climate system and other parts of the environment being adversely affected by anthropogenic GHG emissions. The Court considers that the material scope of its inquiry encompasses the full range of human activities that contribute to climate change as a result of the emission of GHGs, including both consumption and production activities. Turning to the territorial scope of the request, it follows from the Court's conclusions on the material scope of the questions put to it that the General Assembly did not intend to impose any territorial limits to the Court's inquiry. The Court is requested to formulate its reply not in respect of any particular territory or regions, but in global terms, especially since GHG emissions are unequivocally caused by human activities which are not territorially limited. With regard to the temporal scope of the request, the Court observes that while temporal issues may be particularly relevant for an in concreto assessment of the responsibility of states for breaches of obligations pertaining to the protection of the climate system, the present opinion is not concerned with the invocation and determination of the responsibility of individual states or group of states. Rather, the present opinion considers the legal obligation of all states under question A and identifies the relevant legal regime applicable to legal consequences arising under those legal obligations in its reply to question B. Concerning the scope of question A, the Court notes that the unqualified reference to obligations under international law indicates the intention of the General Assembly to seek the Court's opinion on the obligations incumbent upon states under the entire corpus of international law, and not to limit the Court's reply to any particular source or area of international law. With regard to the scope of question B, the Court observes that this question is connected with question A insofar as it refers to the obligations enumerated in question A. Thus, the legal consequences to be determined by the Court are those arising from the various obligations under international law which the Court is called upon to identify under question A. In the Court's view, nothing in question B indicates that the General Assembly intended to request the Court to opine on the legal consequences, if any, for injuries arising out of acts not prohibited by international law. The Court considers that it has been requested to address legal consequences in a general manner, and that it is not called upon to identify the legal responsibility of any particular state or group of states. It also bears noting in this context that the responsibility of individual states or group of states requires an in concreto assessment that must be undertaken on a case-by-case basis. In its view, in relation to question B, the Court is only called upon first to establish the applicable legal framework of state responsibility in respect of states that have breached their obligations to protect the climate system, and second, to outline in general terms the legal consequences flowing therefrom. In doing so, the Court does not prejudge the merits of any future claims that may be brought in relation to the subject matter of the present proceedings before courts or tribunals. As for legal consequences, with respect to a certain category of states that are especially affected or are particularly vulnerable, the Court notes that the application of rules of state responsibility under customary international law does not differ depending on the category or status of an injured state. Thus, specifically affected states or states that are particularly vulnerable are in principle entitled to the same remedies as other injured states. The challenges faced by certain states, owing to their geographical circumstances and level of development, are governed by the relevant primary rules of international law, and thus will be addressed by the Court in relation to the relevant obligations of states under Question A. The Court observes that the second part of Question B inquires about the legal consequences with respect to peoples and individuals of the present and future generations affected by the adverse effects of climate change. The Court considers that whether individuals have any entitlement to invoke the legal responsibility of states or to make a claim in a particular circumstance involving injury or harm arising from climate change is dependent on the relevant primary obligations of states. Having defined the scope and meaning of the questions posed by the General Assembly, the Court then addresses Question A and begins by considering the applicable law. In its request, General Assembly invites the Court to have particular regard to, I quote, the Charter of the United Nations, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the United Nations Framework Convention on Climate Change, the Paris Agreement, United Nations Convention on the Law of the Sea, the duty of due diligence, the rights recognized in the Universal Declaration of Human Rights, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment. End of quote. The phrase, particular regard to, while indicating that the wide range of international legal rules and principles are potentially relevant, does not mean that the General Assembly requests the Court to address every rule of international law, including the obligations contained therein in respect of climate change. The Court therefore identifies the most directly relevant applicable law governing the questions of which it has been seized. It first identifies those rules which are most directly relevant and thereafter determines whether any of those rules are excluded by virtue of the interpretative principle of lex specialis. The Court begins with the Charter of the United Nations, which is a pillar of contemporary international law. The Charter provides that the member states shall act in accordance with certain principles, such as the fulfillment in good faith of the obligations assumed by states under the Charter, including when addressing problems of common concern, such as climate change. Accordingly, Charter forms part of the most directly relevant applicable law. The Court then turns to the applicability of the climate change treaties. It observes that the Framework Convention, the Kyoto Protocol, and the Paris Agreement are the principal legal instruments regulating the international response to the global problem of climate change. These instruments complement each other. Framework Convention establishes the ultimate objective as well as the basic principles and general obligation of states in respect of climate change, whereas the Kyoto Protocol and Paris Agreement respectively translate these basic principles and general obligations into a set of more specific interrelated obligations, each of which gives expression to a broad, practical approach of the community of states parties to the problem of climate change. The Court thus concludes that the three climate change treaties, namely the Framework Convention, the Kyoto Protocol, and the Paris Agreement, form part of the most directly relevant applicable law. In view of the Court, UNCLOS also forms part of the most directly relevant applicable law. With respect to other environmental treaties, the Court considers that the following treaties form part of the most directly relevant applicable law, given their close connection with the issue of climate change. The Vienna Convention for the Protection of the Ozone Layer, which I shall refer to as the Ozone Layer Convention, the Montreal Protocol on Substances that Deplete the Ozone Layer, which I shall refer to as the Montreal Protocol, the Convention on Biological Diversity, which I shall refer to as the Biodiversity Convention, and the United Nations Convention to combat desertification in those countries experiencing serious drought and/or desertification, particularly in Africa, which I shall refer to as the Desertification Convention. The Court is aware that there are many other treaties which are relevant for the efforts of the international community of states to address the global problem of climate change. However, it confines itself to examining the most directly relevant applicable law regarding climate change. The Court then goes on to consider the applicability of the relevance of customary international law. In the advisory opinion on the legality of the threat or use of nuclear weapons, the Court affirmed that the duty to prevent significant harm to the environment is not confined to instances of direct cross-border harm, and that it applies to global environmental concerns. In the Court's view, the customary duty to prevent significant harm to the environment also applies with respect to the climate system and other parts of the environment. The duty to prevent significant harm to the environment is an obligation to act with due diligence. The conduct required by due diligence has several elements to which I shall return later. Determination of what is required by due diligence ultimately calls for an assessment in concreto of what is reasonable under the specific circumstances in which a state finds itself. However, this does not exclude the identification of a required standard of conduct at the general level, depending on the overall character of the risk to the parts of the environment in question. This is particularly apposite with respect to climate change, because the specific character of the risk of significant harm to the climate system is indisputably established. Climate change poses a quintessentially universal risk to all states. This risk is of a general and urgent character, requiring the identification of a corresponding general standard of conduct to be applied subject to the principle of common but differentiated responsibility and respective capabilities. Under these circumstances, the Court recognizes that the standard of due diligence for preventing significant harm to the climate system is stringent. As concerns climate change, a heightened degree of vigilance and prevention is required. The Court concludes that the duty of states to prevent significant environmental harm applies in the context of climate change, and that this duty forms part of the most directly relevant applicable law. Concerning the duty to cooperate, the Court recalls that it lies at the core of the Charter of the United Nations and has been spelled out in the Foundational Declaration on Friendly Relations. The Court has held that the adoption by states of this text affords an indication of their opinio juris as to customary international law. That observation also applies to the duty to cooperate, insofar as it finds expression in many binding and non-binding instruments relating specifically to the environment. The duty to cooperate is a central obligation under the climate change treaties and other environmental treaties. In view of the related practice of states, the Court considers that the duty of states to cooperate for the protection of the environment is a rule whose customary character has been established. This duty to cooperate is intrinsically linked to the duty to prevent significant harm to the environment, because uncoordinated individual efforts by states may not lead to a meaningful result. It also derives from the principle that the conservation and management of shared resources and the environment are based on shared interests and governed by the principle of good faith. For these reasons, the Court considers that the duty to cooperate for the protection of the environment forms part of the customary international law and can also serve as a guiding principle for the interpretation of other rules. It forms part of the most directly relevant applicable law. Turning to human rights law,